If a defendant is out on bail and commits a new felony, can the judge modify or change the bail status? To find out, you have to read People versus Brann, but it's 11 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Brann. The citation for this case is 2024 New York Slip Opinion 00850, published by the New York Court of Appeals on February 20th of 2024. The issue in this case is whether a judge can revoke a bail or securing order decision based upon a new arrest for a felony and how that can be done. To understand and appreciate the context of this case, I think what's helpful to know is that under Criminal Procedural Law 510.10, there are a list of factors a judge has to consider when determining whether to grant bail or release conditions. And they go from A through J. There's things like criminal history, JD history, YO history, risk of flight, things like that. And since 1970, there's been an ability for a judge under CPL 530.60 sub 1 for a judge to reconsider a bail determination once it's been made. So a judge, let's say a judge initially grants $10,000 bail. If later on the defendant does something, buys plane tickets to leave the country, the judge can then, under 530.60 sub 1, reevaluate those same list of factors, those A through J factors, and increase the bail. That's under 530.60 sub 1 since 1970. But in 1981, they changed the statute and added 2A, which said that if a defendant's out on a felony and then commits a new A felony or a violent felony, then the judge has another way to revoke or modify bail. But in that circumstance, if you apply the 2A way, then the defendant is entitled to a hearing to determine whether there's reasonable cause to believe that he committed the new offense. And at that hearing, the defendant has a right to call witnesses, to offer evidence, to cross-examine, and the people can offer evidence and can even submit in their case to prove the case, the grand jury testimony. It's admissible in that particular kind of hearing. But then in 2019, they changed the statute again with the comprehensive bail reform laws. And in that 2019 change, they added additional ways that the judge can modify or change the bail. Specifically, if there's a persistent and willful failure to appear, if there's threats to either to offend against victims or witnesses, things like that. But in that circumstance also, those particular grounds require that hearing we talked about. So what are the facts in this case? The facts are that in 2020, the defendant was arrested and charged with several felonies, including criminal possession of a weapon in the second degree, a Class C qualifying offense, a qualifying offense being bail is eligible for that offense. The judge sets the bail and the defendant makes the bail and is released within a day. Over the next several months, he's arrested 3 more times for felonies. And at that point, the people say, Judge, I want you to reevaluate the initial bail you set back when the first offense happened and you set bail. The defendant objected when the judge tried to evaluate it on those list of factors and said he's entitled to a hearing. And they go to the appellate division. The appellate division sends it back, says conduct the hearing. The judge does and remands the defendant. Ultimately, this goes to the Court of Appeals. And the question here is, because there's been so many changes of law since the 1970 original statute, 1981 amendment, and the 2019 amendment, there was an open question. Does the defendant entitled to a hearing on all these different factors? How does the judge handle a new arrest while the defendant is out on bail? Does the judge have to give the defendant a hearing? Does the judge have to consider only the 2A and 2B factors? Or can the judge consider the sub 1 factors, which basically a revisitation of the 510.10 list of factors? And ultimately, the holding in this case is when the out-defendant is charged with a new Class A or violent felony, a court can modify a securing order under either sub 1, which is reevaluating that 510.10 list of factors, or under 530.62A, which is that reasonable cause to believe he committed a new felony. But the judge has to be clear on the record as to what standard he or she is applying to consider new bail. If the judge is silent, the court will assume that following the 2A factors, the reasonable cause to believe that a new felony has been committed, and then the judge has to show that all the procedural requirements of the hearing were complied with. So the judge is going to consider it based upon a reevaluation of the 510.10 factors, which is sub 1. then the judge has to be very clear about it and make a record of it. And that's the case of People versus Brann. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.